Now that you had your lunch break, you had some time to think about this definition of an AI system here. So what do you think about it? Yeah?
I think it's very general, like even just a normal program would I think fall under this definition. So it's
Yeah.
like very
Extremely. Extremely generic because varying degrees of freedom, or it may exhibit something or whatever. Um, it's very hard to know. So varying levels of autonomy, it may exhibit something, it could influence something. It doesn't really mean anything, right? So what is eventually AI? And eventually courts need to rule on this. So what is common is so-called commentary literature, which is written on constitutions and on laws to provide some guidance, some interpretation, what all of this could mean. And there are, for example, comments on the Constitution of Germany, comments on all sorts of laws, comments on state laws. And there are now some comments coming for the AI Act, since the AI Act was ratified in spring or in summer eventually, it was published. And it takes 6 months for it to become effective with regards to the bans and the other parts within the next few years. So we need comment literature to provide some guidance. And a friend of mine, he has been editing a comment on that, a huge book that will probably be 1,000 pages or something. And I wrote together with one of the other co-editors the comment just on this definition here. And I think we wrote like 30 pages or something, because in a comment you need to cover also historic definitions, what others define, how the law has evolved, rulings. We don't have rulings yet. So these comments will also get updated over time as soon as courts look into this. So exciting times for lawyers. They're happy to cash in. Auditing companies are very happy to cash in. But if you're a company and you need to earn money, you're not happy with this. And we'll see how all of this evolves in the next few years. I think one of the fundamental issues of the AI Act is that the EU Commission always claimed AI was totally unregulated and one would need to regulate all of this. There was a huge legal vacuum. I wish to have seen that legal vacuum, because from my perspective, there is probably not much of a vacuum, because if you put AI in an airplane or in a financial product or in a car, there's lots of vertical regulation on systems. So eventually your system, which includes some AI, needs to comply with that vertical regulation. And it doesn't matter how the system is implemented, if it's a bit more or less AI. But now we have, in addition, this horizontal approach. And that horizontal approach would lead to probably also extra regulation, not only that, but contradictory regulation, because you have vertical versus horizontal and all of this. And that's a problem. I was active in lobbying, and we were able that at least automotive is also largely excluded now from the AI Act. So not just military and intelligence, also automotive to a large extent. But automotive, they need to come up with their own rules in vertical regulation that would eventually be adequate or related to the AI Act. Not 400 pages, but maybe the key essence that can be summarized on a few pages. And that's already some progress. I always said in those hearings and private discussions, the AI Act should be killed altogether, because the EU also demanded a lot of transparency for AI, but they didn't provide much transparency on this law and a lot of internal discussions. We have to see how this evolves. Some lobbyists, they want even more regulation. They now say the new parliamentary term in Brussels that we would need to regulate AI even further. I think we should cancel the AI Act altogether. Now, what do you need to do if you work in a company or need to run your own company? Every company that from now on does AI, and this definition is probably quite broad, needs to look into the AI Act. All AI use cases need to be classified. They're low risk, high risk, forbidden, and that is not that easy. There is a company in Munich, they're called Applied AI. They belong to TU Munich. They did a few years ago a study on one of the earlier drafts of the AI Act. They looked at 100 use cases, and some they were able to classify from their customers, but about half of them, they were just unable to classify from those rules. They didn't know in which risk category it could fall. And that will create uncertainty, and uncertainty is always an issue when you need to innovate, because if there's too much uncertainty, you may not innovate or elsewhere. London is becoming an ever bigger AI hub. They are finally benefiting from Brexit, because if you're based in London, you don't need to comply, but you need to comply if you offer your services or products in the EU. But still, if you can do the R&D outside the EU, it's probably easier. Research is also excluded from the AI Act. So research is first of all out, but when it comes to commercialization and putting it into production, you ultimately need to comply. So these are some of the insights on the AI Act. And if you now work in a SME, a small or mid-sized enterprise, you're unable to understand 400 pages and execute it. So what is currently happening is that large companies, they're working together with lawyers to build sort of checklists. So maybe for specific problems, you can have a 2-page checklist in order to achieve most of these requirements. And so our industry associations, say for automotive, for engineering, for healthcare, currently working on checklists and best practices that their partner companies would need to comply with. So they are probably rather able to comply than if they need to understand those 400 pages. And, you know, I'm not against regulation at all. Regulation is important, but I think regulation is getting out of control. I was just at a big conference 1 or 2 months ago, I think last month. And there was a lawyer saying one of his customers is a large automotive company. They have 100 people there just tracking regulation all around the world that could affect them. And then they study it and they see if it affects them. And they are now offering an AI solution to their customers to check which regulation could be relevant. And there are some AIs for the AI Act. They could tell you whether you're most likely compliant or not. But I don't think an AI will solve the actual problem. The actual problem is that there are too many rules that no one is able to understand. One thing that is currently being discussed, who would actually enforce the AI Act? So companies need to be compliant, but who would actually certify them? Because companies need to get their AI certified. And there are some huge concerns that an R&D of the AI is cheaper than the certification or the auditing. And auditing will not be done, or certification will not be done by will not be done by government. It will be done by private companies, and companies like TÜV or DEKRA or others, they're now starting AI subsidiaries for this. But someone needs to certify those that are certifying. And for that, you need some government infrastructure. And in May, we had a hearing about that in the Digital Affairs Committee of the German Parliament. And expert witnesses proposed all sorts of special stuff. Some proposed we need an AI agency in the federal government with thousands of people that would finally control AI all over the country. I said we don't need such an agency because, first of all, most companies are not just doing AI, but they are putting AI in applications, say in agriculture, in healthcare. And for those, there are market surveillance agencies. So do you know, in Germany, we have almost 300 market surveillance agencies run by government for different industries on the federal level. And I said, there are already a lot of them. And if you put AI in agriculture, your main concern is agriculture, not the AI. So maybe such market surveillance agencies, they could offer a little bit of work around AI as well. But first of all, they have the agricultural expertise, which is most crucial. Now it looks like the Federal Network Agency, so the Bundesnetzagentur, could become in charge of AI and the AI Act, but this is still to be discussed. Fortunately, not the Data Protection Agency is in charge of the AI Act, because this would further kill innovation. I also wrote written evidence for Parliament in addition to the oral evidence I gave in the hearing. So it's all in the Nextcloud in case you want to read it. And we receive a huge list of questions a few weeks in advance and need to answer them and submit this. And then some of these questions are discussed in a 2-hour hearing. But these hearings are pretty short. Usually these hearings take 2 hours and they invite, I don't know, 8 or 9 expert witnesses last time. So every expert witness in the beginning has a quick opening statement for maybe 5 minutes at the most. Then there's one round of questions, so each group in the parliament, then in the committee, can ask questions for 5 minutes to any expert witness they want. You get some questions, you give a quick answer. They may ask someone else, and then the next group, but then there will be a second round usually. And they always hope there will be closing statements, but there's usually no time for closing statements because 2 hours pass very quickly. And all of this is recorded and available on the website of the parliament. It's important that such hearings are done, but what I see is there's often not much of a follow-up of the hearings. Like the committee does a hearing and then it's over. And maybe individual members of parliament reach out for further discussion, or one of the parties or something, but there is not much that the committee does a second hearing on the same topic 2 months later and say, we've in the meanwhile thought about this. We would like to ask you more questions. And I think sometimes that could be very helpful, but that does not exist. Meanwhile, around the world, there are other approaches to regulation. Now, regulation can mean something totally different around the globe. In the EU, it largely means bans, rules, not really how to foster innovation. If you look at China and the US, it's different. For example, President Biden has signed lots of executive orders in the last 2 years to foster AI innovation in the US federal government, that agencies need to hire AI experts, need to find ways how to integrate AI. So that's also regulation, but not much bans, mainly to foster innovation. And there were a few proposals in California now, including this AI safety bill that the state parliament there voted on, and it would have been similar to the AI Act, but in California. And Google and other big tech, they were obviously very concerned about this because it would have applied to their headquarters, and they threatened they'd be moving to Texas, for example. So the governor, Gavin Newsom, he vetoed that just in September. And that AI safety bill is dead now in California, because probably would have been a big hit to big tech. But what I noticed around the AI Act is big tech tried to influence the AI Act, especially OpenAI, and spread a lot of warnings about themselves and their product and large language models. And this led to additional regulation that they are probably best to comply with compared to smaller competitors. So if you add a lot of rules, maybe big tech can comply better than smaller competitors. And this seemed to have been some of the motivation why they spread all these fears. So I've seen a lot of very strange stuff in the last few years, and the lawyers are cashing in enormously because for them, the AI Act is a big business. And I've been warning about the AI Act ever since. I'm not against regulation, but what I'd like to see is maybe where's the legal loophole? And we've seen some loopholes maybe around fake news or influencing elections, all these kind of things that the AI Act actually does not address. Mainly addresses stuff that is regulated already. And obviously, some law firms, they're desperately looking for new clients, especially some law firms which had all these diesel mandates, which are now over. So they're looking for new deals, especially around AI and privacy. And I always said that big tech may become even stronger because of the AI Act, and we will hurt local competitors here in Europe. And there was a law firm with one of their partners. What they did on LinkedIn to me was really like stalking. Whenever I commented or posted somewhere about AI Act, they always commented I would get paid by big tech to post that. But I said, hey, this is the AI Act would be supporting big tech, which I don't like. So but they just try to generate more traffic in order to get more clients. But I found some way to create pressure on them to stop this, because in each state there's some institution that looks at lawyers and whether they are compliant, and they can cancel your license to practice law. So when I threatened with that, it stopped. It's not nice if you get stalked on LinkedIn just because you're sharing your opinion as a professor. I've said the AI Act is a so-called regulation, in fact, because there are different types of EU legislation. So if you ever hear an act, it's a regulation that applies like this to the member states. So it needs to be ratified by Parliament, by the Council, by the Commission. They all three need to agree on it, and then it applies as is to the member states in local law or in national law. There are also so-called directives. So regulation is Verordnung, directive is Richtlinie, and directives, they come with some freedom how they get implemented on the national level. And there are more EU legislations like decisions, recommendations, opinions, and all of this that you may see again. And there are some definitions for this here. Now, there is not just the AI Act. There's more digital regulation. And I guess I remember there's this course, I think it's in the 3rd or 4th semester, taught by David Bohmhardt, right? This legal course. Did anyone attend it? I don't know when it is, in the 3rd or 4th semester or something, right? Yeah. And he's a friend of mine, and he's an expert and talks about all of this in great detail in his course. But I just want to show the big picture here, because not everyone has taken that course. There's more than the AI Act. There's the GDPR, the General Data Protection Regulation, which was initially meant to promote competitors in the EU and to make sure there is not a super powerful big tech. Unfortunately, these rules are so complex that big tech can comply better than local competitors. So it has created the opposite effect. Then there is a product liability directive. In German, that's something like Produkthaftungsgesetz. This is super important, and it applies to all products, and it's very important that this exists. So if you sell products, they need to comply with certain rules so they are safe, like toys for children or washing machines. The problem was that this product liability directive was from sometime from the 90s or so, and it did not include software as a product. And that had, in fact, created a lot of legal issues, not just around AI, but around software in the last few years. That has become increasingly more difficult. And this product liability directive has now been updated, and it includes software as a product, which is, I think, already great progress and something super important. And it's good that this has been done. However, in addition to the AI Act, already 3 years ago, the so-called AI Liability Directive was proposed, another EU directive specifically for liability around AI, where I've always said from the beginning that that wouldn't be needed at all if you update the former one, because this popped up 3 years ago, but no one talked about the product liability directive. And I said, maybe update the product liability directive so it includes software, and add something about AI if you feel it necessary. And then you don't need the second one. However, the first one was updated, and still now in the new legislative term, there is a certain hope in the European Parliament to pass the AI Liability Directive, for which I don't see much need if you had just had a chance to update a product liability directive, because AI is not a product itself, it's always part of a product. So this is something that may be coming, and you in a company, you need to look into this. And if you run your own startup, you need to look into all of that. Then there is something that you may have noticed since March or so. If you search something in Google, like a street, you get this map in the Google main search, but it's not clickable anymore. Who has witnessed this? Yeah, and when I noticed that, I first thought this was some, some cookie issue in my browser or something, but it appeared on all devices. And then I looked more into it, and it actually has to do with something that's called the Digital Market Act, DMA. It's a regulation that was also passed a few years ago on the European level and is now effective in the member states since spring. And the Digital Market Act has, I think, a very good intention, like all of this. But if it works is a different question. The intention was that you would want to avoid, or you didn't want super powerful ecosystems that could stifle competitiveness. And they said Google, for example, could fall into there, or Apple with their app shop or something like this. And they would need to open, or you would need to be able to run different browsers easily on your iPhone and this kind of stuff, because you want to avoid these super strong ecosystems that could limit competitiveness. And the Digital Market Act, again, has a good intention, but leads to lots of stupid consequences, like Google is not allowed to link in the results to its other search services. So in the past, if you search something, you may also get other proposals, not just maps, maybe flights, whatever. If you type in New York City, it's proposed flights before. And this doesn't happen anymore because they're not allowed to do it. And they can still show you a map, but the map is not clickable anymore. So you need to click on your own up here somewhere in the map if it's shown, or you have to type in maps.google.com and then type in Deggendorf, Blumenstraße. Because they feel this could increase competitiveness. I really don't see how something like this could increase competitiveness. I think it just hurts users who need to take more clicks, more keystrokes all day long just to get what they want. One easy way how to avoid this is you just use VPN and run your traffic through London, and then your Google still magically works. So one student here wrote in the chat that he has noticed this for quite some time. It's probably since March or something like this when I noticed it. The DMA was passed together with the DSA, the Digital Services Act. This has been in the news now for the last few weeks because this is the law that they want to use to fight hate speech and fake news and all of this, so that social media networks would need to delete certain content that someone flags as problematic. But who are these flaggers? Someone needs to choose these companies or these organizations that flag content as whatever. And there's obviously the huge risk of a political bias, as we see right now in the discussions in Germany, that a left-wing government would probably favor to have left-wing trusted flaggers that would flag things that are not in their own interest. It's all like Orwell warned about, but it's now becoming a reality. And I think it's also absolutely unnecessary, because if there's illegal content or content that would lead to criminal consequence or to punishment by court, obviously it needs to be deleted. But if you suddenly have to delete stuff that government doesn't like, or that could be someone feel unhappy with, it's not illegal. So we're slowly moving, this bar lower than illegal just because someone doesn't like some content or some government. And this is, I think, becoming a big problem currently. If you see how the federal government is selecting these verified flaggers, or what they are called. So there's a huge risk it gets politically misused. I think, again, there's a good intention to delete wrong content or illegal content, but who eventually defines which content you should be deleting and which one you shouldn't, because it's not just illegal content that gets deleted. So big challenges. And if you build your services or your AI, eventually you need to comply with most of this. DSA and DMA only applies if you have reached a certain size. So your startup will typically not be subject to this, but larger companies and larger services. And the lawyers are obviously very happy because there's lots of revenue to be made. So if your Google Map doesn't work anymore, you know now why. When I posted this on LinkedIn, there was a lot of negative responses that people claimed I wouldn't be caring about privacy, whatever. Well, this has nothing to do with privacy, because for that we have the GDPR, and it's my choice to use Google. And I just want to use the Google Map and not take extra keystrokes. And I think if you have millions of people who need to take lots of extra keystrokes every day, that also costs money. So these are some of my thoughts on this regulation, but David discusses it again in his course, which you said was last semester. So it's always in the summer. Yes. I already warned, I think, early last year that the AI Act could severely impact ChatGPT at that. So that there was some discussions around a draft of the AI Act at that time that was early last year. And the consequences would have been that ChatGPT may be disappearing. And I posted that in the night on LinkedIn. I think it was in January, February last year when I was in Shanghai and had some free time in the evening and just did a post about that and went to bed. And next morning I woke up and had like 100,000 views on LinkedIn, and it turned people crazy. And then I was asked by Heise, the publisher behind some of the famous magazines like X and CT, to contribute a commentary. Now ChatGPT is not banned, but what could be happening is that ChatGPT in the future, because of the AI Act, is only available in a limited version here in Europe. And that's what we already see with some of these other foundation models, I think from Google or whoever. They're saying we're not making this in the EU available anymore because of compliance concerns. And that's why the consequence of things like the AI Act, they have a good intention, but the consequence could be that it not just impacts competitiveness because innovation becomes more difficult, but that an end user doesn't get what he or she could be getting just if you run your if you live in London or in Zimbabwe or wherever. And that's something we're facing. So I think one of those who are cashing in, aside from the lawyers, are the VPN companies, because there's probably a bigger demand in Europe for VPN in the next few years. And there's also a super interesting article that I uploaded in Nextcloud. It's called Tech Panics. It's about historic tech panics. And this one was published last year by Patrick Rady and Daniel Castro. I know Patrick Rady, and they wrote this. They worked at that time at the Center for Data Innovation, and they did a historic collection about tech panics. So people are now scared of AI. Historically, you can make the link to many other of such panics, and you can even put a panic cycle there of different stages of tech panics. And there were tech panics around lots of other things. I think the printing of books or whatever, take a look into it. And with some pseudo correlations or whatever. And that books would turn people crazy, whatever. So there was panicking around books and printing presses and some other things. So take a look at that report if you wish. And now it's about AI. Next point that I discussed only briefly this year are paid. So we've now looked at regulation. And when it comes to patents, AI also plays a role. So when you build products and you want to sell them, typically you need a patent. And you need to check if someone else already has a patent on that. And there's some criticism nowadays towards patents that one would not need patents anymore. I think patents have a very good intention because they also make innovation available to others. So it's not just trade secrets that people keep behind closed doors, but you're actually sharing knowledge. But for doing that, you get an exclusive right to use it for a certain number of years. So patents, once you build products, play a crucial role. Now there are some questions. Can we patent AI itself? Can we patent a neural network or something? In Europe, we cannot. This has been clearly argued now, and it's clearly defined that an AI as such cannot be patented because you cannot patent in Europe algorithms or mathematical models. In other parts of the world, this may be possible. In the US, it's a bit different. Like Google patented different neural networks. Google even patented the concept of classification in one of their patents. It's unclear if such patents are ever enforceable, but they just put lots of lawyers on this, and they're happy probably if some of these patents get accepted. So you could take a look at that, but we are here in the EU, so we cannot patent AI as such, but that often leads to a misunderstanding. The misunderstanding is often that you could not patent anything related to AI at all, and that's also wrong. If you put AI in a device and it creates some novel effect, that's what the wording says, then you can obviously patent that device. And it includes some AI to achieve something, yes. Something like this could be... Exactly, or some machine that creates PET bottles and uses some AI inside for the control loop, that's all perfectly fine. But not the actual, or just the AI, but the actual system. It's called an apparatus in that language. And these patents, it's a totally different language, which looks horrible if you look at it. So this is the one side. The other side is slightly different. Can you patent something that was proposed by an AI? So if a generative AI generates you something, maybe a new drug or some new device, and it comes out of an AI, can you patent that? And that was unclear for a while. And now for 2 years or something, this has been clear, because so in Europe, we have the European Patent Convention and the case law of the boards of appeals of the European Patent Office. And that one has looked into it, and now it's very clear in the EU, something derived or proposed by an AI cannot be patented. Now, what do you do if you have some innovation that came partially out of an AI? I guess what a lot of patent attorneys would be saying is, you don't need to reveal that it came out of an AI. You just claim you did it yourself, or you still made some substantial changes to it, and maybe don't reveal that it came out of an AI. But this is not my advice. I just hear that from various patent attorneys. And if you're curious about patents and AI, there is again another article here in our Nextcloud. It's a book chapter that is 32 pages long, so quite long, but discusses this in detail. The book chapter is from Anna. Anna is one of my associates, and she was here, I think, 2 years ago for a guest lecture in innovation management for AI. And she is a patent attorney in the field of healthcare and life sciences, but with a strong link to AI. And in one of my books, she contributed a book chapter on patents, on inventions involving AI in the life sciences and healthcare. There's lots of general stuff in here about what is actually a patent, what can be patented around the world, what cannot be patented, and how does AI play into this, say, AI in the context of patent law and so forth. So probably the first half of the chapter is unrelated actually to healthcare or life sciences, only a later part. So if you want to read this to get a better understanding of patents and what can be patented and what actually a patent is, take a look at this. She was here last year, but I don't think we actually have the recording, because I only started recording this course last year. And and this year I'm putting it on YouTube for the first time. So we don't have that recording, but if you want to read Anna's book chapter, it's in Nextcloud. Now, there's another legal topic, which are copyrights that has been keeping people busy for the last few years. You have probably heard about cases like this, that writers and newspapers are suing OpenAI for copyright issues, that they claim OpenAI has something used they were not allowed to use for training their AI. I guess who of you is aware of such lawsuits? It's been, raise your hand, or online. It's been in the news now for a while. How does this affect you? Well, if you build machine learning models, you also need to be aware of such situations, because if you don't look into it, maybe you're building a product that your employer then cannot deploy, or your employer gets sued and maybe sues you for having done illegal activity, or if you have your own startup, it's all your problem. So we need to look into this. And while I'm very critical of the AI Act, there are some positive news here in the EU. Copyrights are handled in the EU also as a directive. So member states have some freedom in how they implement it. And this was revised I think, some years ago. Yeah, exactly. So we see here, well, it was last amended, the national law, in 2021, but this major revision of the copyright directive on the European level was, I think, some 5 years ago. And in Germany, we have the Act on Copyright and Related Rights. In German, this is the Urheberrechtsgesetz. And what does it say? Around 5 years ago, something was introduced here, which came through this revision of the European directive, and it's section 44b, text and data mining. Nowadays, people don't talk much about data mining. This was a term that was popular some 10 or 15 years ago, but it says something. First of all, the first section is very interesting because it provides a legal definition of text and data mining. It says, text and data mining means the automated analysis of individual or several digital or digitized works for the purpose of gathering information, in particular regarding patterns, trends, and correlations. Sounds to me like an okay legal definition actually for machine learning. Because the distinction between data mining and machine learning is, again, vague, and whoever you talk to, you will get something different. Some people say data mining and machine learning is the same. Some people would say data mining focuses on more steps than machine learning, maybe also collection of data and visualizations and stuff like this, while the machine learning is only the actual learning. But I would say this is actually an okay legal definition for text and data mining. And text mining means you're doing this with text, not just some other information. And then the next two sections say something like, it is permitted to reproduce lawfully accessible works in order to carry out text and data mining. Copies are to be deleted when they are no longer needed to carry out text and data mining. So what is lawfully accessible means not trade secrets or not something you have stolen, but for example, what's available in books and on the internet. And you can create copies for this in order to carry out your data mining, means your training. And section 3 says uses in accordance with subsection 2, sentence 1 are permitted only if they have not been reserved by the right holder. A reservation of use in the case of works which are available online is effective only if it is made in a machine-readable format. So 2 and 3 mean you can use it if it's lawfully accessible, but there can be a constraint on it. And if it's digital or online, the constraint must be in a machine-readable format. It's absolutely unclear what this last statement means. What is a machine-readable format? What does it need to look like? Is an entry in the robots.txt file enough to keep a crawler out, or do you need to put this in some other way? No one knows, and this is something that will probably keep the courts busy in the next few years. But first of all, if there's nothing mentioned, you can just use it if it's available online for training your models. Now, recently, there was some association or industry association for publishers or something. They hired a professor and a lawyer, and they came to a totally different conclusion in their written evidence that all of this actually would not apply to machine learning. But I guess, you know, if you get paid very well to write some written evidence, maybe this may have some impact on your results. But the large understanding in Germany is that this applies to machine learning, and there are similar laws in the other member states, because that's all a consequence of this revision of the copyright directive a few years ago. So things that are available and not reserved, you can use for training your models. So it gives us lots of freedoms, and we will probably have far less issues than this one here in the US. So this can really spark innovation. Obviously, some lobbyists, they're trying to revert this and constrain it even more. But newspapers and other publishers, well, they need to find new business models. And I think if, say, some publisher sues that they are not included in your AI model, say someone sues OpenAI that they get removed, which is even not technically fully possible, but you would have to retrain, then, well, maybe no one cares about you anymore because your content is not anymore in these large foundation models. And then maybe you want to sue again that you actually get included because otherwise you're just out of business. So there's strange stuff that will probably be happening in the next few years. But here, section 44B only addresses training. Now, if your model predicts something new, who has the copyright on that? Say you have a generative model that predicts something, generates a text. Who can claim the copyright? Yeah. Right now, actually, no one really. So the machine cannot hold the copyright because the machine cannot really invent this and thus claim the copyright. So right now it's unclear. But again, what some lawyers are advising, not my advice, but some lawyers are saying if you substantially amend this text and don't say it originally came out of an AI, maybe you can make that claim it's actually yours. This is what some lawyers are advising. We'll see how all of this evolves in the next few years. You don't need to be lawyers. I'm not a lawyer either, but you need to include such people if necessary or raise these concerns to your manager when you work on such stuff, because it can lead to dramatic legal consequences. And this here applies in the EU. If you work for a startup in the US, obviously this doesn't apply there. In Japan, a minister even proposed last year that you should abolish copyrights altogether when it comes to training AI. I don't think they followed on this, but it was proposed at least by one of the ministers there in the cabinet. And now we come to the last part, military applications. And we only have a few slides left for today. We've had this slide here before. Will the Terminator become a reality soon? And there are lots of fears, obviously, around an AI being used in a military context. And there was a very interesting conference just a month and a half ago in Seoul, in South Korea. The conference is called REAIM. It's called Responsible AI in the Military Domain Summit. This conference took place last year for the first time in the Netherlands, and now this year, the second edition took place in South Korea. And I was there also as a speaker. I hosted a session there together with a friend of mine who is a tech lawyer. He's a lawyer that deals around AI, military, 3D printing, and this kind of stuff. And we went there to host our session. And the conference was super interesting. There were all sorts of people from all over the world, researchers, politicians, lots of defense ministers from all over the world, ambassadors, military industry, all obviously from the Western world. There were no representatives, I guess, from North Korea or Russia or China. Would have been helpful to actually include them because everyone works on this stuff now. And I found this super interesting, but I saw there was a lot of fears. And a lot of the policymakers, they're sort of concerned that AI just gets out of control, like in the Terminator, and starts a nuclear war. And there were not that many people at that conference that actually do in-depth work on AI. So my friend and I, Andreas Leupold and I, we did a session in which we said mission possible, how you can build and deploy safe autonomous weapon systems, which was not the main direction of the conference, because most of the direction of the conference was how to ban all of this stuff altogether or why AI was dangerous. And we said, to us, it's very simple. Other countries are working on this. And if we don't work on it, this will mean lots of lives lost in the next war. And We all don't like wars, but it will happen. It's a sad reality. And we don't want to lose that war. And it doesn't mean we need AI to launch nuclear bombs, but AI in military can mean a lot of stuff. It can mean maybe in logistics, in planning, in satellite analysis, all super helpful. You can put AI in weapon systems. It could be a defense system, for example, to shoot down like a self-defense system for a vessel that could shoot down a rocket. I don't think there's much that can go wrong. And I don't think we should have a human in the loop for that, because human in the loop is just too slow to take that action. And nothing wrong can really go if you have a battleship on the sea and it shoots down a rocket that approaches. And maybe this is in the night or it's a hypersonic missile. You have to shoot it down. And there's not much that can go wrong. So here, a fully autonomous system is absolutely reasonable. It's maybe more critical if you apply it in, say, more an offensive system that would mean lives lost. Do we want that? That's a political discussion. The federal government wants to largely ban this right now in Germany. But again, the enemy or potential enemies, potential adversaries are working on this. And it could mean lives lost at some point in the future. And there are often these claims that it was all illegal to use, and we've looked into it. So my friend who is a lawyer looked into the Geneva Conventions, looked in international humanitarian law. We read a few books on this during the summer when we prepared that session, and we saw there isn't really anything preventing the use of AI. And there is lots of regulation if you want to use military force, at least if you follow international laws. You cannot just deploy military force and kill someone. There's lots of prior steps that international humanitarian law requires you to take, like certain checks, whatever. But then you can use a weapon system and it can be autonomous. There are no bans at all for this in the current laws. And maybe an AI can react faster, maybe better. And here in these discussions, we also see there's a lot of double standards, higher standards required for humans than higher standards required for the AI than for humans. Maybe again, let's demand the same standards. And I think an AI could also massively help maybe to spare civilians. Because in wars, unfortunately, lots of civilians get killed, and an AI could maybe help us to spare their lives. And this is actually what the international humanitarian law requires, not save troops, but save civilians. And their AI could be of huge help. And I think if we put too many constraints on ourselves, this would mean just the next war means many lives lost. If you look historically, most wars were lost because of lack of technology. And that's why this doesn't mean we want to build a Terminator. And when I talk to generals and military decision makers, there were also lots of people from the US at the conference, like some of the people from the Pentagon doing strategic planning there. I don't think these people want fully autonomous killing systems like a Terminator, because it could always turn against yourself. I don't think they want this either. They still want some kill switch, but it should be able to make decisions autonomously, because a human may be just too slow to react and select a target. Or maybe if an internet connection is lost, these systems wouldn't be working anymore, but you still need to combat. And from a legal perspective, we also propose to make a link to product liability, because product liability does not require that your systems is totally free of errors. You're required to follow the state of the art of engineering and science when you develop and deploy the system, and that you monitor the state of the art. But it doesn't mean that your system has to be fully free of error, because if that was required, we wouldn't have any products on the market, because something theoretical could go wrong. But if that ever happens, you are not liable, because you have followed the state of the art and you have documented that. And that's why we think that link should be made more to product liability, something we didn't see at all in the legal literature in the last few years and at that conference. And we presented our proposal at the conference, and I could write a follow-up article with Andreas in the Frankfurter Allgemeine Zeitung that also appeared in September. You can either zoom in to read it or find the article on the internet. So there are lots of ways for you to access these texts if you wish. And it's a hotly debated topic. It's an active topic, and we've just finished a much larger article detailing some of our views, because here in a newspaper, you can write maybe 800 to 1,000 words, and we just wrote a much longer text that will probably appear in December in a major defense magazine, which we are sharing some of our thoughts, and we'll be presenting all the results from the conference in December in the Defense Ministry in Berlin. So already excited about this. Feel free to read the text if you wish, to see some of our thoughts. I know it's a hotly debated topic, and we all wish there were no wars, but unfortunately, it's not the reality. AI and law, it keeps a lot of people busy. You can also apply AI to courts. So a question is, do you want like a robot judge that automatically sentence you or make some ruling? I don't think we want this. But again, in Germany, we also have a lack of labor, a lack of talent among judges. Lots of judges are retiring and lots of prosecutors. And we don't want that people have to wait 5 years for their trial. So this kind of stuff should happen quicker, and the AI can support a judge, maybe look into documents, can review things that maybe judges and prosecutors don't want to review in detail, like certain types of illegal pornography, because someone has to review all of this among the prosecutors and judges, and it makes people sick. And maybe an AI can do most of the reviewing, and maybe a human only needs to double check some of it. Could already mean, because some police officers, they're really done if they have to review for 2 years such stuff all day long. So here the AI could help. It can help to support the judges. And there was a very good discussion that we had last year with Beck. Beck is the leading German publisher on legal literature. They're based in Munich, and we had a big event there. And I was one of the 2 keynote speakers there. I was a keynote speaker, and Mr. Eisenreich, the Minister of Justice of Bavaria, was the other keynote speaker. And it was a very positive event that we did there with judges, with lawyers, with politicians. And the minister is overall very positive about AI. So he's in charge of the courts and the prosecutors, and he's heavily advancing AI now with the goal of speeding up trials, helping to address the lack of labor, the lack of talent, and all of this. And he's heavily exploring this. There are obviously some legal concerns to be looked at, but it's something we're exploring right now. And I work closely with the Minister of Justice on this, and I think it's a big opportunity to speed up trials and help judges. And I too myself, I don't know when I just talked to a few weeks ago to the former head of a big funding agency in Europe. And he was concerned, he's now out of this, but he said, well, what if all the reviewers are using AI to review grant proposals, review papers submitted to journals? I said, well, maybe not too bad, because then finally someone actually reads that kind of stuff. Because if a professor reviews a paper or a grant proposal, no one reads 50 pages. You just skim through and maybe look at some of those parts. But if you let an AI review it and you double check it or you verify it in some way, someone actually reads the proposal still. Someone or something. The same with courts. I don't think a judge can review 10,000 pages submitted to a trial, but the AI can read it. And maybe the judge can make some ultimate decision. So that's it about my views on all of this. And the case study is meant for you to share your views. One thing is important. So we have these presentations in about a month from now. You know the dates. And I will open the submission portal in the iLearn course in the next few days, and then communicate the deadline until when you need to submit. Remember to submit a topic which needs to address largely some managerial issue around an AI project or an AI transformation in a company you are working at or a company of your choice. 3 to 4 students per group. You submit all of this, and we'll do the presentations online. in about a month from now, and I'll communicate this list, and it's just a pass or fail because the study regulations for these 2 degree programs don't assign a mark to these internship accompanying courses. You also need to register for the examination for this course. The course is probably not called Innovation Management for AI in Primus, but PLV1, so Praxisbegleitende Lehrveranstaltung 1 or Internship Accompanying Course 1. Something very important, if you don't find things in Primus where to register, please don't write me. Always write the Center of Studies. I don't have access to that either. So I only have access to Primus once the exams take place to enter the marks. So I don't know how to register for exams. The Center of Studies knows, and they are at your disposal every day and most happy to help. And your presentation, again, should then take around 15 minutes, and there will be a 5-minute Q&A session at the end. And I want as many of you as possible to attend. You should at least attend the whole day when you are presenting. Ideally, all sessions, so this can lead to a good Q&A session. And I hope you have fun with the case study. If there are any questions in the next few weeks on the topic or whatever, feel free to write me and I'll be happy to help. Are there any questions right now, also with regards to the case study? I guess then we're done. Thank you very much for all these good discussions here, and enjoy the remaining Sunday, and make sure you form a group soon. And we have the forum and iLearn to connect. And I hope, just wait a second, you all got some good insights, what you need to look at when you commercialize AI, how to choose AI projects, when maybe not to pick AI. AI strategy is something that also Katja talked about yesterday, and the guest speaker today, Philip. We talked about legal issues, international competitiveness, because you need to convince stakeholders, and it's not just your bosses or your customers, sometimes your colleagues or workers in a factory, because they are concerned that the AI would put everyone out of business. And if you don't convince them, it will be awfully difficult to introduce AI then. There was a question here.
Yeah, 50 minutes, so roughly 5 minutes per person.
Yes, approximately. So everyone in their group needs to be presenting, obviously. I've seen weird stuff like students arguing. I didn't say you need to be present at a presentation, and one guy created the slides and didn't show up. That's obviously a failure. And I don't have a specific format for the slides. You're very free in all of this. Good. We are done then, and I wish you a good remaining Sunday. Take care. Bye-bye.